Great job, Yuri. What happens that I've seen a lot is general counsel to many companies around the United States that we represent together, that you get a letter from the general contractor to the subcontractor, and they say to you, you obligated yourself to protect and defend me against certain items, and if you don't, like a loss or defects or property damage to the building or to other people's work, then you're going to go ahead and be responsible to defend me. I'm asking you to tender this lawsuit or this claim to your insurance carrier. And there's a bunch of different insurance policies, kind of what you just said. You have certain choices. Sometimes you got to think about, what insurance do I have? So we have, maybe you can like summarize, what is the insurance that a subcontractor or GC would typically have that they would then tender the policy to?
So thanks, Hal. So the one that I spent the most time discussing today was what is commonly referred to by the acronym of a CGL policy. So that is either a commercial general liability policy if you're on the insurance side, and if you're on the policyholder side, it's a comprehensive general liability policy. You might say, well, why the difference in the vernacular? Well, because of course, as the policyholder, you want that coverage to be comprehensive. As the insurer, you don't want it to be so comprehensive. So that's what we spent most time here discussing, and that is generally what's called an occurrence-based policy. It's triggered by an occurrence, which is, an hour discussion of itself. But there's also a errors and omissions type policy that might apply. Sometimes a sub's work goes into areas that are more design oriented, for example. So an example might be a stud and drywall sub that also does some exterior cladding work on a building where, the issue arises as to whether their work complied with shop drawings or something like that, or a mock-up. And so that can potentially trigger a different type of policy. So it needs to be studied when the claim comes in.
Well, I think the point that you raised, which is really good, is that you need to inventory your policies, because you're going to forget them in the heat of the battle. Because
Yes.
With today's overload of information, your mind isn't always working, as sharp as it should be all the time, unless you're very lucky and you have a good team around you and you yourself are familiar with this. But it takes years and years and years to kind of get the instinct of what you're talking about. And I'm really glad you brought this subject up, and you did a really great job summarizing it. So like you mentioned, like policies that he wrote, well, those design policies, or the, I think they're called professional, what do they call professional design, or something like that. Mainly they would be, as you said, for somebody that's signing a contract and they do a design build. Okay, then they take that responsibility. Then you've got the word in contracts, design assist versus design build. How far does it go? I was talking to a few of my construction manufacturer clients this week in California. I think I mentioned this case to you, this California council. I mean, your state has California licenses for contractors. My client was an out-of-state manufacturer of window products, and the subcontractor claimed that we were not going to get paid. We're having a battle trying to get paid on the job. We've leaned it, we're litigating it. And he asked in the litigation, he said, hey, I'm suing you because I paid you money, and you were a design build party, therefore you're a contractor, you're not just a manufacturer, and I want to take all the money I paid you, since you didn't have a license, and gorge it out of your pocket and give it back. Now, naturally, as counsel, who was at the beginning of the job, which we were, and we sent out the notices and we filed the liens, we weren't even thinking of this possibility could happen. You got to give these guys credit as a subcontractor for having such imagination. But when we pointed out the terms and conditions to the judge said, even though you're providing shop drawings, you're really not the engineer of record. You're really not the designer. The fact that you did what are called structural calculations in a window frame to make sure that the structure of your product will, in conjunction with the building, be in accordance with code compliance, so it's not falling out in heavy winds and rains and things like that. That doesn't make you a contractor. That makes you a manufacturer that's doing your job and making sure you're engineering your product correctly, not the building. And the judge threw the claim that we were a construction contractor and therefore needed a license, thank God, out the window. Okay, that was there. And the best part about the case was then the judge ruled that he decided this because he used the words design assist in the standard terms and conditions, and that we weren't responsible for, like in Gene's client's case, consequential damages, late deliveries, the terms of sale. So as a lawyer who was always writing this, it was nice to be able to tell the audience that we now have a set of terms that a judge has adopted, and he's already ruling in our favor on the license. I'm guessing, but we don't know, we'll find out, that he'll take those same terms of sale and put that for the benefit of our client. So our trial lawyer actually worked with us, and we strategically were pissed that he would dare claim we were a contractor and steal our money back. But then we said, all right, we're probably going to win this, but let's get our terms of sale adopted here too, and convince the judge otherwise. So it kind of backfired on a subcontractor who, it's hard for me to like express myself so professionally, who tried to take my construction manufacturer's, products that he never paid for, and try to take the little money they did pay us back. And in California, that could happen. You must be aware of that as a California counsel, if you don't have a license.
Yeah, so California is one of the states that is probably most draconian on that issue. So it's no surprise that they would try to trigger that to gain an unfair litigation outcome, frankly. But those types of provisions exist in other states as well, obviously. So very important when you're a even a third tier provider providing work on a project where you're crossing state lines, thinking, well, I'm not really doing work on the project. I'm sort of just a vendor, just providing a product as opposed to a service. Those lines are often blurred.
Right. Yeah. And there's people that are on a legal network that specialize in representing these issues in contractor licenses, as you likely are doing too. So one of the things that I think is important, speaking of California, let me share my screen with the audience for 1 second if I can. Is a case, let's see, that came down called United Riggers versus Coast Iron Steel. And Yuri's talking a little bit about this today. So what I liked about this case, it started in Los Angeles, and it ended up in the Supreme Court of California. And I really like the perception of the Supreme Court of California. I think the audience would be interested. The judges say, this is the reported case, so it's very interesting. This case is about construction, physical and statutory. Spurred by late payment problems in the construction industry, the legislature established payment deadlines and imposed penalties on owners who delay payments to their direct contractors, and penalties on direct contractors who delay payment their subcontractors. But these deadlines include an exception relevant to this, that direct contractors can withhold monies from subs in circumstances where a dispute has arisen. And what we must decide is whether this exception allows withholding when there is any dispute between the party, or only when there's a dispute directly relevant to the specific payment that would otherwise be due. So I'm going to be sending some information out to the audience today afterwards, and we'll be taking some of the slides and information from our panelists and circulating that in the next few days. I'll send a copy of this case. I'm not going to tell you how the Supreme Court ruled. I want you to read the case. It's very exciting. It's pretty short, and I think you'll enjoy it. And, what is the Supreme Court of California going to say? Can somebody withhold all your money or just the amount of money that's in dispute? I think it's 150% of the amount. So we'll see exactly how the case is decided. So let's pretend we argued it today and we're waiting for the court to make a ruling, and you'll get the surprise of seeing how the ruling will come out. This has been a really great audience, great questions people ask, and I want everybody to know National Lien and Bond has one passion. We work together, 50 lawyers in 50 states, notice services all across the country, trade associations, credit groups, and people like you to do one thing. We all together want to get paid when we do our work. And I think that's something that's really great for you as suppliers and subs and GCs to do. And it's great for a GC to pay a sub, and it's good for a sub to pay a supplier, and everyone to get along, after, they shake out whatever the problems are. Recently, we've been pushing non-litigation, but problem solving. And I can say that so far in the month of September, we've been able to solve a bunch of cases where I called up two people today. One Gene and I are working on in Bowling Green, Kentucky. And I asked the general contractor's project manager, hi, I'm not here to file a suit. I'm here to solve a problem. And then he complimented Gene's lien. He acknowledged that the lien on funds was good, very strong. He realizes they have payment bond claims as a GC, and the subcontractor also has payment bond claims. So the GC, through indemnity, said, hey, will you negotiate with the subcontractor? I said, as I said, I'm here to talk and listen. Let him call up Gene or myself, and we'll solve it, or call our client and we'll talk. Then we had another case recently, actually, that coincidentally Yuri and I are working on. We don't know what's going to happen with that one. And Yuri's client's having a little problem where we're trying to help out a little bit, where they need the GC who's been paid 2 years ago to pay attention. Like, when are we getting paid? So we called up the public job, and after like going round and round with COVID, can't get a hold of somebody. Somebody called me back today and said, are you the attorney or the client? I said, I'm the attorney for the client, a subcontractor that built your facility, and 2 years was in construction late. You know that. He goes, who's your client? So I told him. He goes, well, I can't speak with you because I'm not a lawyer. You can speak to our lawyer, but better yet, let me have either the lawyer call you or have the general contractor call your client. I go, good. Why don't you do both? And let's see what happens. So now there was no dialogue. We'll keep our fingers crossed, okay, that we'll get something done, who knows. But in the meantime, I want to thank everybody for coming. I don't see any more questions and answers. So ladies and gentlemen, we enjoyed having you. And mechanicsLien.com, that's sponsored by National Lien and Bonds since 1985, is a great organization. We've studied the laws from the first Mechanic Lien Act from 1791, 230 years ago. We're going to be celebrating that in December. Stay tuned, and you'll hear about more information this year on your lien rights in your states and information. And you'll be getting an invite to participate in sharing information, particularly in this case, subcontract provisions that are going to help you avoid one-sided contracts and get you paid. So have a nice day, everybody, and look forward to get paid on your work. Thank you.